please the court, Nancy Kaufman for Bar Counsel. I'd first like to address why the decision of the single justice should be reversed and a judgment of disbarment enter. There are three primary reasons why we are asking this court to do that. The first point is that an indefinite suspension is a markedly disparate sanction given the crimes here and the respondent's history of discipline. Disbarment is the typical sanction for intimidation of a witness. I'm not aware of a decision involving actual witness intimidation from this court which resulted in less than disbarment. Matter of Hyatt is probably the closest case to this, and in that case, the lawyer was also involved in a family dispute and was convicted of similar crimes, including witness intimidation, and also raised in mitigation before the single justice that he had been hospitalized during part of the proceedings and had mental health issues. He was found to have waived those issues, and the single justice entered a judgment of disbarment. Not only was this respondent convicted of witness intimidation, but he was also convicted of 2 counts of violation of a restraining order, which is a serious crime because it involves the administration of justice, criminal harassment, and he violated the conditions of his probation. So when you take the constellation of crimes, certainly disbarment is warranted. The single justice acknowledged that disbarment was warranted in this case and that the records fully supported the unanimous decision of the Board of Bar Overseers to recommend disbarment. The only reason that disbarment was not ordered was that the single justice observed unresolved emotional issues in the presentation before the court, an argument on the information. That is the only reason. We say that that is not sufficient, not appropriate, there was no evidentiary hearing, and that unresolved emotional issues are not mitigating. And I would like to focus on the word unresolved. First of all, these underlying crimes do indicate emotional problems. We have the victim who was stalked and subjected to psychological abuse for a period of over 2 years. It's in the record. We have the criminal harassment. We have the witness intimidation of the psychologist who was carrying out the evaluation that the sentencing court had ordered as part of the probation for the restraining order violations and the harassment violations. So clearly there are some emotional issues involved. In fact, the trial court in the Hingham cases, the restraining order and harassment cases, ordered as a condition of probation that the respondent undergo an examination and follow treatment recommendations. So we know that there are emotional issues, but they're not resolved. And the point is that they have to be acknowledged and resolved in order to be mitigating or to be even considered as mitigating. So we have this problem here that the recommendation of disbarment was reduced to indefinite suspension simply because Mr. Patch has unresolved emotional issues. The other indication that they are unresolved, in addition to the conduct before the single justice, is that even in his brief to this court, he continues to characterize his offenses as mere proximity violations and justifies his witness intimidation conviction by saying that he had been subjected to improper examination by the psychologist. So we can see that calling what he did to the victim in the harassment case and the restraining order case simply a proximity violation doesn't seem to have any relation to what the trial judge saw during the course of that trial, which he characterized as stalking and psychological abuse. In addition, to be convicted of harassment, you have to have done more than simply commit some kind of proximity violation. You have to have willfully and maliciously engaged in a knowing pattern of conduct or a series of acts that would cause a reasonable person to suffer substantial emotional distress. That's the definition of harassment. So we're not talking about mere proximity violations here. The second point that I'd like to raise is that this respondent waived the right to have his emotional condition considered. He did not raise it in his answer. He was represented by very able counsel. He had filed 2 separate answers, neither of which raised his emotional condition in mitigations. We have no evidence regarding what his emotional problems are, what he has done, if anything, to address them, which appears to be nothing, so that it's not proper, as was held by the single justice in the Hyatt case, it's not proper to consider those emotional conditions on oral argument before the court on the information that the board filed.
And why should we not send it back to the board to consider whether those emotional issues are of consequence?
Well, there are a couple of reasons why that shouldn't happen. First of all, this case has been pending for many, many years. It has been delayed over a number of years. Number 2, this respondent had a lawyer, a good lawyer. It was obviously decided by them that he would not testify in the hearing, and Mr. Patch is able to object to a lawyer. He is fully capable. He's shown, this record demonstrates that he's fully capable of complaining about his lawyers and raising objections. This actually interferes with the decision that was made as a tactical decision, we have to assume, for him not to bring this issue into play during the bar discipline proceeding. If Mr. Patch had not had an attorney, if there was some indication that he hadn't had the assistance of able counsel, it might have been appropriate for that issue to be remanded. There have been circumstances where single justices have sent cases back to have that issue evaluated. But I believe in each of those cases, there was some medical evidence presented to the single justice to justify sending it back, and some acknowledgement by the respondent lawyer that there was a problem. That did not happen here. There was no argument made before the single justice by Mr. Patch that he had an emotional problem that contributed to his crimes and that should have been evaluated but wasn't evaluated before the hearing committee. So it would be inappropriate at this point to send it back to have that issue examined. I think that we have to assume that he and his counsel made a rational decision not to do that. And furthermore, there's no evidence before this court or before the single justice that it should have been sent back, that there was some error in overlooking that. And again, we get back to the problem that it's not resolved. This problem is not resolved. Again, if he didn't have a problem, he probably wouldn't have committed these crimes, because these crimes indicate some kind of emotional problem. Who does this? But that's not a defense. And that brings me to my last point here, that the focus in bar discipline is not on the respondent lawyer. It's on protecting the public and the integrity of the bar. And in this case, Mr. Patch's personal interests were elevated over the interests of the public and the bar. We have no indication here that he has addressed his problems, that this conduct is not going to occur in the future, nothing.
But he's not practicing law.
Well, he's temporarily suspended. He's been temporarily,
But he would be under what the single justice did as well, prevented from practicing law.
well, yes, I mean,
Conditions that the single justice imposed upon any readmission.
well, yes, I mean, he would have to, but there's, again, we get back to what is the standard sanction here and whether this is mitigating.
No, I'm only addressing your point about protecting the public.
There's protection of the public and the integrity of the bar. We have here a markedly disparate sanction. This is a case that calls for disbarment. Not only has he committed crimes that called presumptively for disbarment, but he has a history of discipline. He was suspended for 3 months for being held in contempt on 7 occasions in connection with his divorce. That's a matter of substantial aggravation. And in that case, he was given some consideration for emotional problems that he had in the late 90s. But how many times is that going to happen? The point here is that there should be no consideration given at this point because it was waived, it's not raised, and there's just no justification for it. I see that my time is up. So unless there are some questions about a motion to dismiss, I'll sit down.
Thank you.
Thank you.
May it please the court, Thomas F. Patch, I am the appellee. First, I would, I wish to apologize to the public, this court, the bar, and all others involved, that this matter has arisen because it was never my intent for this to transpire. First, I simply would like to address the motion to dismiss. Contrary to what Bar Counsel had indicated, I did not render the issue moot by asking this court to consider the entire record. I expressly reserved my right to press the motion, and it's pretty straightforward. This was simply Bar Counsel did not comply with the rules with respect to the designation of the appendix, and there were two motions on this. The motions speak for themselves. What it was particularly troubling to me was the Rule 16K certification when it was clear that the rules had not been complied with. Moving on to the merits, without waiving that motion, moving on to the merits. The guide star for attorney discipline, thank you. Excuse me. Is the effect upon and perception of the public and the bar while obtaining a just result. My criminal convictions are still on appeal, which is a very difficult situation for me because I have CPCS assigned counsel because of my situation. And it's been a struggle. My current CPCS appellate counsel has, I believe, a September date to file the brief in the misdemeanor and the probation violation matters. And I'm still waiting for assembly of the record in the witness intimidation case. As far as the witness intimidation case, I would like to point out that this case is troubling. I presented documentation in connection with motions to the board that seems to suggest that people have been using the licensing process and the criminal process to gain a collateral advantage against me, coming after my license, essentially to shield their own wrongdoing. In the case of the psychologist, you have his letter in there, correspondence between he and his attorney, telling his licensing board to somehow tell his licensing board that it's relevant that I'm going to lose my license to practice law. And that wasn't without even the felony matters being tried yet. As a defense to my concerns expressed to his board about what had transpired during the evaluation. And as this court has indicated in Commonwealth versus Hamilton, this iteration of the witness intimidation statute, which is not the version that Mr. Hyatt was convicted under, this has been broadened, and even this court has indicated that it wanted the legislature to take another look at this statute, in particular in terms of retaliatory conduct. And I've also provided the court with a case where the predicate for the witness intimidation, the criminal proceeding, was a post-evaluation mental health proceeding, which had previously been held in Commonwealth versus Woods in 1998 to not constitute a criminal proceeding. So there's substantial, right there on the face of it, there's substantial cause for this court to take pause and be concerned that I am going to be disbarred as a result of this felony conviction. And particularly what my concern is Bar Counsel has indicated, if I get my convictions reversed, there's not a direct correlation to me getting reinstated. So that's the reason why I've been trying to stay on deferral, because I believe that these convictions are going to be reversed. And it hardens me, actually, to hear Bar Counsel state that mere proximity violations are not a basis for a criminal harassment conviction. Precisely. That's right. And that's exactly what happened. And that's the reason why I believe the criminal harassment charge should be one of the reasons why the criminal harassment charge conviction is going to be reversed. Looking at the discipline for purposes of a felony conviction, I pointed to two matters, matter of Nickerson and matter of Driscoll. And basically, this court has to decide every case on its own merits. And if you look at those two particular cases, you have two instances where attorneys pled guilty to felonies. In Nickerson, he pled guilty to one, I believe it was a federal felony, and he received a 1-year suspension while engaged in the practice of law. In the matter of Nickerson, she pled guilty to 14 felony counts and received an indefinite suspension. My belief is that this case needs to go back on deferral. That's where it should have been. I still, to this day, I have great concern how this case came off deferral, because my case was on deferral until 2 months after I initiated a lawsuit against a person who's collaterally involved here for defaming me, and I was just in Superior Court on that case. Because they were using the fact that I was convicted as apparently a defense to their own wrongdoing with the Department of Environmental Protection. Again, using my status to a collateral advantage. Bar Counsel says I have no right to ask for that. I think it's within the discretion of this court to do that, should it choose to do so. But at the end of the day, Justice Spina, I believe, got it, and he understood. And he decided, quite properly, that the appropriate discipline, if discipline was going to be imposed at this time, would be the indefinite suspension. With respect to my prior discipline, Bar Counsel stipulated, I stipulated, the board stipulated, it was entered as an order of the single justice that I was diagnosed with clinical depression. And in fact, there was medical documentation as of that time, and that I was receiving medication and counseling. That was at the time of the conduct alleged as the basis for the restraining order and the criminal harassment, and then leading to the witness intimidation charge, which, for purposes of correction, it was not 2007, it was 2006. It was charged in Hingham District Court. It got transferred to Plymouth District Court on a motion by my appointed counsel, because it was pretty clear I was not going to get a fair trial in Hingham District Court. So the Regional Administrative Justice transferred it to Plymouth District Court. So there, contrary to Bar Counsel's statement, there is evidence, medical evidence, that I had these issues. And I acknowledged it. And Bar Counsel acknowledged it. And the board stipulated to it. And the single justice entered it into an order. So this whole idea that I'm not acknowledging that there are these issues I respectfully submit, is incorrect. There is evidence of that. So at this point, I respectfully ask this court to uphold the decision of the single justice. He did not abuse his discretion, and I believe he reached a just result with due consideration of the discipline imposed and the effect upon and perception of the public and the bar. Thank you.
Thank you, sir.